Afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge, where we discuss all things edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, the cutting edge. Those of you joining us live today are receiving early bird access to this episode. That means you get exclusive access to our speaker and you get to ask questions. So please, if you have any questions, type them into the comments section below and we will make sure we address it. If you happen to be unable to be with us live today, however, episodes are released each week following the live broadcast. So be sure to hit that subscribe button and click the alerts icon to make sure you don't miss an episode. Today, we have Neil Anthony with us for our Superstar series. Papa Don loves to honor anyone who has a stellar outcome at trial using the cutting edge techniques by giving them a platform to speak about what worked for them in trial. Neil represents victims of motor vehicle crashes, defective products, unsafe property, police misconduct, dangerous medical devices, boating accidents, and animal attacks in Florida. We'll put a link to his website in the description below, as well as his contact information so that you can reach out to him after this episode with any questions you have about trial. All right, Neil, tell us how you used edge techniques to achieve justice for your client.
Hey, thanks, Jenna. I'm really happy to be here. It's kind of an honor. It's really special, and it's a privilege to get to talk, in one of the KTI Keenan's podcasts. Don asked me to talk today about a verdict I had in April in Punta Gorda, Florida. I'm on the east coast of Florida. I traveled over to the west coast. Punta Gorda is a smaller venue, very conservative. And I had a case there of a stipulated liability, minor impact, lower speed collision, with no treatment or injury at the scene. And because it was a very deserving client, we were able to turn that into a verdict for $1,400,000. And that was on a $35,000 State Farm offer. It really, the big picture, I can say, first of all, I wanted to tell you guys, there was amazing teamwork from my team. I have a trial partner who's a new American. I don't say immigrant, I say new American. And her parents come from Sicily. She's quick, she's strong, and she's a killer, and this was her first plaintiff trial. I have a paralegal that I work with who is a single mom, had been for 20 years, and she considers personal injury work and helping our clients almost like a ministry. I have another paralegal I work with that I've nicknamed Sherlock because she's such a snoop and she knows the system so well. So this was a big team effort, which I was able to lead really a lot because of the training. I can honestly, genuinely say gifts that Don Keenan has given to me. I was honored as Trial Lawyer of the Year by KTI. And Don spoke and he said, these teachings, these KTI teachings put so many lawyers on the map who were totally unheard of, who nobody really ever knew. And I got to tell you, I was sitting there listening to that going, man, that's my experience too. I'm in West Palm Beach, Florida. We have inner circle lawyers here. We've had Bob Montgomery here. We've got some of the biggest names. We've got national inner circle names here. So I was a little fish in a big pond. I consulted with Keenan back in 2010 on a child injury case and took everything I learned from that, went to trial on a dram shop case, taking all the KTI teachings, never had done it before, but taking all those teachings and got a verdict for $11 million. Almost $1 million of it was the consortium verdict. And I wouldn't have been able to do that without the gifts that I just mentioned that I was given. people in my community didn't believe it when the news came out. It was like, well, how is that possible? I don't know that guy. He doesn't have big verdicts. He's not at one of the big trial firms at that time. So it was almost unbelievable how taking the teachings of KTI, really using them and putting them into effect, has just created amazing results for me many times over the last 10 years. So now about this verdict in April. Maybe I should start with talking about, there were things that I did different from what I teach when I teach the openings college, okay? And Jenna, is everybody on here listening, or are they all trained in KTI? Do they all go to the colleges? No?
Nope, no secret sauce, please.
Oh, okay. Well, I think what most people know is starting out the case with something that really grabs your attention, okay? That typically, I think everybody knows, is a statistic. We start with a statistic. And then we go into safety rules. Why? The statistic lights your hair on fire. It says, oh my goodness, this is a real problem. The safety rules show this is preventable if people actually do the right thing. Well, what do you do in a stipulated liability case? In this conservative venue with a conservative judge, I knew if I started out my case with a statistic, I was going to get an objection. There was going to be hustled to the bench. If I had done it in a motion in limine, I probably would have gotten denied. What safety rules do I have when it's stipulated liability? The woman that hit my client was elderly and she passed away after. The real rule violation was impaired driving because her faculties were impaired by age. But I wasn't going to be able to get into that because of the stipulation. But I know the philosophy. I know why we do what we do. So I changed the beginning to, the first thing out of my mouth was to that jury in the opening statement, was talking about the incredible qualities of my client. And then right after that, instead of talking about a rule violation, I ask a question. And so this was the question, what do we do when someone is harmed by the clear, undisputed negligence of another? Okay, and then I asked that question 3 times in the opening. I ask it right in the beginning, I ask it after damages, and I ask it after disarming the defenses. And I kind of thought of it as a call and response. For anybody who's into music, there's the call and the response. I couldn't say right from the beginning, it's the defendant's bad conduct. That's why we are here. In Florida, that's inadmissible. I mean, it would create a mistrial. So just by asking the question, it suggests the answer. What do we do when someone is seriously harmed by the negligence of another person? And then by the end, it was, what do? We teach them that when someone is harmed, you don't call them a liar, you don't unfairly call them a cheater, and you don't malign them in a public forum. You don't take away every bit of dignity that they ever had in front of a judge and a jury in a public place that's on the record forever. That's what you don't do, right? So I was able to actually bring that all together at the end of the case in a way that the real rule became, don't lie about people, don't malign people, and don't cheat people. That's the rule. The rule was about the defendant's conduct. So it had to be subtle, it had to be implied, couldn't come right out screaming with it, or it would have been a mistrial and probably sanctions against me. Okay. So those are some of the changes that I did to the opening statement and some of the reasons why I did them. Maybe I could talk a little bit about the voir dire. The voir dire, what I'd like to say about the voir dire, maybe I could talk a bit about how I've really changed over the years my philosophy of voir dire. Back in the day for me, and I'm 51 years old, I've been practicing law for 25 years. There was a concept of cause is king. And so the idea was the worst jurors, you got to get them off for cause. You got to go after them for cause. You got to get them off that jury, or no matter what you do or no matter what you say, you're not going to get a verdict. And I don't disagree with that. There's a ton of truth to that. But that truth has to be balanced with what to me is a bigger truth. And the bigger truth is that we are building a community of understanding. We are building a community of people, those jurors and us and our client. We want solidarity. We want community. We want them to feel what our client feels. And I call that, or somebody calls it tribe building. And that's the balance to the cause is king approach. So I ended up doing 0 challenges for cause in my voir dire because I didn't have anybody for cause, because I didn't push any of the jurors into cause like we experienced lawyers can do. Okay, so if somebody said to me, for instance, in voir dire, you know what, some of these big verdicts, they really bother me. I think things can really get out of hand sometimes. My response might be, hey, I understand. You know what? Sometimes I feel that way too. And I might ask them to let me understand, tell me more about what they know or what they've experienced that led them to feel that way. And then I might ask, because of your experience with that, does my client start out a step behind? Does my client start with 1 strike against, or whatever iteration I'm using? And if he says to me, or if she says to me, no, they don't start out, they start out even to me. You know what I'm going to say? I'm going to say, thank you. I appreciate that. Instead of going, well, now I understand that you can say that now, but given that you've already said that you have a negative feeling about some of these big verdicts, you think my client might feel that she might be a little bit behind in your eyes, maybe compared to somebody that doesn't have that. Like I could go into all of those, lawyer talk with her, with that juror, and maybe get her stricken for cause, maybe get the words from her. Yeah, I have a reasonable doubt about whether I could be fair. That's the standard in Florida. I might be able, through my experience and my learning and my talent and my lawyering, I might be able to do that. But if I do that, one thing I'm doing is I'm showing everybody on the panel, I'm showing all the prospective jurors, and everybody's going to sit there, that I can take somebody's words and do the lawyer trick of making them say what I want them to say, not what they originally said, but what I want them to say, because it serves my purpose. So I'm stepping right into that negative connotation as a lawyer. But number 2, I'm blowing a tremendous opportunity to be myself, what I want the juror to be herself or himself. If I say, thank you for letting me know that, what I'm communicating one step back from that is I accept you at your word. I accept what you're telling me and I thank you for it. I appreciate it. I'm not, well, that's not really true, ma'am, and here I'm going to show you why. So when I ask the jurors to believe me at the end of the case, or through not the end, but through the whole case, through my opening, through my directs, through my crosses, I'm asking them to believe me. If I can't believe them and I show that, how can I then ask them to believe me? So that's a real big reason why it's very important to me now to balance the cause is king approach with the tribe building approach and weigh far more heavily on the tribe building side of it. I'm not saying I'm right about it. I think that there's amazing lawyers out there with records better than mine that would disagree with me. But I have to pick for myself, and we all have to pick for ourselves what our trial persona is going to be. And I decided, based on somebody's example, based on my mentor's example, based on Don Koenig's example, I decided that I was going to be open, I was going to be authentic as best as I can, and I was going to be honest with the jurors. And so that's every chance I get in trial to show them something I wasn't supposed to reveal a truth that the defense thinks is really great for them, to own every fact. I'm there, I'm working credibility. That's my most valuable thing to me, because I want my client to be believed. I believe my client. I want them to be believed. Nothing is more important than that to me. That kind of like rolls in also to the concept of really being yourself. We have to figure out who we are as trial lawyers. I know I've had to do that. It's still not like I did it and it's done. I consider it an ongoing process, a journey, as some people like to call it. Just part of my life, like sitting with my emotions, like really caring about myself. If we can't really care about our own suffering, I don't really believe that we can care about the suffering of others. If we can't, we start right here with us. So with credibility, we got to know who we are, and we can't try to act like lawyers like that we think are really good. We have to do it our way. So to me, it's important to understand the reasons why you're doing what you're doing, whether you're following KTI or something else. I follow KTI. So it's important to me to know the reasons why we're doing everything that we're doing, so that I can present it in a way that's authentic to me. I could touch on spontaneity for a second. Spontaneity is extremely important to me. You hear people say, oh, she thinks really well on her feet, I never really thought that about myself, like coming up as a lawyer. I always thought, oh, wow, if I don't know what I'll do. I could get caught flat-footed. There were like those voices in my head of worry and doubt. But as I've grown up in the law, I know that being able to think on your feet means being intensely prepared. I equate one with the other. So, intense preparation is extraordinarily important to me as a trial lawyer, because trial is a live event. You don't know what's going to happen necessarily, but the harder you work, the more you study, the more you imagine, the more you focus group, the more you listen to what people think about your case, the more you look at, imagine, and see the angles, the more prepared for trial you're going to be. So when little things come out that are different, you're not going to get caught flat-footed, because they're going to be the things that you haven't heard before are going to be very close to everything that you've already thought about and that have heard before. And then you can strike like Cobra quick with your response. So, some of these notions that you have to be innately this, you have to be innately a gifted orator, or you have to be innately like just a quick thinker and so fast on your feet. I don't believe that. I think that a lot of that is accomplish through preparation. Focus groups. Focus grouping is an enormous part of my practice. And I will confess to you that I did not focus group this case I tried in April. And I think it was because of COVID, and I hadn't really figured out how to do my Zoom focus groups yet. I since have, and I since have done Zoom focus groups, but I hadn't at that time. I am not the very precise dissector like some people are. If you ever do a focus group, if you see Don Keenan do a focus group and you see his focus group memos, they are in so detailed. They are so connected to the demographics of who is saying what, and connected to the experiences of those that are taking positions. And the thinking about it is on a level to which I have not gotten myself. And honestly, I'm not even close with focus grouping. But that aside, focus grouping is still enormously helpful to me. Early on in my career, people at my firm would hire like a big jury consultant that would set up the focus group and read the jury instructions and read an outline of the case. And then, one lawyer would get up and then another lawyer would get up, and then you'd go back to your room and then you'd watch on TV. I found, I know that's very helpful for a lot of people. I found that to be kind of a disconnecting experience, because when I started focus grouping myself, I was the one asking all the questions. I was the one taking all the answers. I was the one digging deeper based on the answers that they were giving me. And in that doing, I was learning. And so if you're like me, if you learn by doing, then doing your own focus groups will teach you an enormous amount about your case. And for me, it gives me such a comfort level because I've been talking to strangers about my case for hours at a time, 1, 2, 3, maybe 4 times before trial. So now I've already talked to people. I've already done this. So when I'm standing in front of a jury, now I'm already comfortable talking about all the issues in my case. And I'm able to simplify. Like, quick example, I did a slip and fall in Chipotle that also resulted in $1.4 million verdict. That number's happened twice now. There must be some good mojo to that number for me. And it was a roof leak issue. And so one of the focus group participants said, well, was it a freestanding building? I was like, yeah, so what? Tell me why that matters to you. He's like, that means it wasn't anybody else's fault. I said, oh, I get it. You mean like a landlord or, another tenant? He's like, yeah, you could be in a building and somebody leaves the water on upstairs and that's not your fault. Or, he had all these other reasons. And so by the time of trial, I can get there and say, this was a freestanding building that this company owned. There was nobody else responsible for keeping the floor safe but them. And I know what it means. So I have the moral authority because I've heard it from people who already believe it. I know how impactful it is. So these are the reasons that focus grouping is so important to me. It's getting comfortable and it's getting the data, the information I need about my case and how to present my facts. Although I do have a long way to go in my learning how to do the demographics, connecting people's demographics and connecting people's experiences to be able to predict their verdicts. That's somewhere where, somewhere over the rainbow for me, right? So I'll get that at some point. You got to have people you trust with you, when you try these cases. And I started talking about that from the beginning, when I started talking about having a good team. You got to have people you trust. And I said to the paralegal that I told you about that I trusted. I've tried all my cases with her for the last 10 years. I said, Eileen, like, what do you think people need to know about how we accomplish this verdict? And she said, honesty and openness. I was like, oh, okay, that's right on. And she said, preparedness. You didn't miss a beat. And then she said to me, you cannot assume that the defense lawyer's buffoonery is not going to make an impact, So you got to watch out for their buffoonery. Even though we totally dismiss it as garbage, you've got to be able to deal with it at trial. And we did all those things. And then the other thing, which came as we talked about it for just a couple minutes, the other thing was the preparing of the client. And when I was getting her ready for her deposition, this was a neck fusion case. I said to her, had you ever had neck issues before or complained to a doctor of neck issues? She said, no, absolutely not. I never had a problem with my neck before in my life. I said, well, we're going to revisit that because I'm going to have all your medical records soon, and just kind of hold the phone on that answer because we need to see what your medical records say. She was 100% honest with me, okay, when she told me that. There was no lying in her. But when I got her medical record, well, lo and behold, she had fallen on ice. She lived in Buffalo. She hurt her shoulder. And when she treated for the shoulder, the chiropractor put, she's got a stiff neck and neck pain, okay? If she had said in her deposition, no, I had never had neck pain a day before in my life, we would have walked right into the defense trap of them calling her a liar. And they would have been able to finagle it. They would have made it seem true. Even though it was a lie, they would have been able to say it with some confidence. But they weren't, because what did she say in her deposition? Well, I didn't remember it because it wasn't a big thing. But, I looked at my medical record, and right there in there, it said I had neck pain when I hurt my shoulder. I don't remember having the neck pain, but I must have had it because I told the doctor, or it's in my medical record. So preparation is so critical. Discovery for me is so critical. If I am disarming defenses like it's a minor impact, well, I've got to be dealing with that in discovery, not just Neil Anthony pontificating at trial. I got to get that from witnesses, and from my doctors at least, and at best from the defense doctors. So I'm working that the whole time. And you better believe that my client's describing what happened to her body in that car and why it didn't hurt for a day. You better believe that the defense doctors, the CME doctors, are talking about, yeah, they've done surgery on people that didn't feel pain until the next day. And yes, people can get injured in accidents where the car is not badly damaged, but their spine can be. So that all has to be laid out from the very beginning of the case. So it's critical to do it in trial, obviously, but you got to do it all the way along. So I think I've talked now for about a half an hour. I can't see anybody, so I don't know. I don't know my audience right now, which is a little bit. It's a little different.
It's kind of like talking to yourself, isn't it?
Yeah, it really is, Jenna. That's
because you can see yourself. It's like a mirror. It's like pep talk in the morning. This is how the trial went. Yeah, Neil, you did awesome.
Right. So, if Jenna, if you have any questions, or if anybody has questions, I'd be happy to answer them. Or any information that anybody would like to hear about, I'm happy to talk about.
Yes. Yeah. I have a few things that I would love to hear more from you about. And, I wanted to share something with, this authenticity thing. And I don't know if you saw that my law partner, Young Ji Ham, did a Finding Your Voice episode with me about very similar things, about how we need to be authentic. But I also always want to remind people that it's an ongoing journey, because you think you're being authentic. In fact, I know that I've won verdicts because of my authenticity. And then I screw it up still. I recently, we did an adversarial focus group, which is kind of the whole, like you were talking about, the whole enchilada, I guess, soup to nuts, voir dire through closing, and you watch them deliberate. And I did it the first time, we got a really good verdict. Second time, I wanted to tweak a couple of things because our trial had been continued 4 times. And because I was being a little bit too forceful, I was being a little bit too hard on the defendants. They still gave us way more than defense is offering, but they cut it in half. And they were, even for people, like Neil or like me or like Dawn or whatever, it's still an ongoing thing to make sure you feel like you're being authentic. And now, since Dawn has tried, hundreds of cases, he walks into a courtroom and he knows who he is and he can just do it. But I want to give people permission to know that it's not going to be you're not going to just knock it out of the park every time. You might have an awesome verdict and then forget to be who you are and kind of fall backwards. How do you feel about that, Neil? Has that happened to you? Have you had a similar experience?
Well, I had it in this case.
Okay,
in this case that I'm talking to you about. I love that you brought that up. Thank you. I said I didn't focus group the case, but I did perform it at my yoga studio that I go to in front of my 2 favorite yoga teachers. One of the teachers is all feeling, and I could see every word. Her body was moving with it. She just she was totally in it. The other yoga teacher was just kind of like looking back at me, like looking for the chinks in the armor. I could read that on both of them. And they're giving me feedback. I didn't understand what you did there. You used too many words there, and so I modified my opening based on that. Mm-hmm. Then I work with psychodramatists in psychodrama training. And I did my opening and part of my voir dire for my psychodrama group. And they gave me a lot of feedback, which was very important to me, particularly with respect to my authenticity. Mm-hmm. I felt like I went way too far with the neurosurgical CME doctor. Mm-hmm. I was so angry at myself for weeks after the video deposition for trial. And the voice inside is saying to me, oh, you screwed it up. You were too hard on him. The jurors are going to hate you for it. That was totally unnecessary. You could have done so much better. But it turned out to be okay because the defense lawyer's dog was barking in the video.
Oh, so they didn't use it.
And no, they used it. And one of our jurors said, I guess he's a veterinarian too. So my indignation at what he was saying that I went overboard with, I got away with. They didn't punish me for it, but I 100% know what you mean. And I do struggle with, did I go far enough? Did I go too far? Where's the line? So yeah, I'm thinking about that all the time, Jenna, and I'm glad you brought it up.
Yeah. And it is something, as long as you're conscious about it, you can keep learning. And I just remember thinking after that focus group, I was like, well, if this happens, and because I was just like you, I was so upset because my client has this devastating brain injury and the defense is that she doesn't have one at all. And I'm like, that is just the most ridiculous thing. And I'm so angry and upset. And so I laid it all out there, and I felt good about it because I was like, I'm laying it all out there and this is ridiculous. And the focus group was like, we didn't like that one lawyer. And I was like, shoot, I can't have that, But as long as we're aware of it, at the end of that, I was still like, well, I'll take it. Worse, if that happens, in real trial, I'll take it because the number was like 3 times what defense is offering. But, as long as you're aware of it and you just keep thinking about it and keep getting knocked down a little bit when we go too far, and better to do it in front of a focus group, better to do it in front of your yoga instructors, better to do it in front of your psychodramatist than the jury, right?
Jenna, were you able to give yourself a break? Were you able to be kind to yourself and gentle with yourself after you heard those nice strangers saying, I don't know about that one lawyer who was so aggressive?
Yeah, it was hurtful.
Yeah.
But I was like, you know what? Nothing the focus group says is wrong. It's like the customer's always right kind of a thing. How I delivered it is wrong. So when they said, well, I didn't like that person, I did take it personally at first for about 15 or 20 minutes after the focus group. And then, we chatted it out in the law firm and I was like, nope, they're right. Mm-hmm. I need to dial it back a bit. So, and that's for anybody who's listening and anybody who listens to this later. Neil talked earlier about different things focus groups do for you, right? It's not just about figuring out what demographic to strike or who to keep or who to get rid of on a jury. It's also about practicing your own skills and being able to take criticism and still stand up and be okay with it and process it in a healthy way. It's kind of cathartic in that way. It's very good for building who you are as a person. So do focus groups to try to figure out who you want on your jury, what evidence you want to present, but do them also for yourself and for practice and for getting better at your craft. All right, let me see what else I wanted to talk to you about. Oh, so I have a couple of selfish questions for you because I wanted to learn from your, when I read your blog, I wanted to reach out to you, but it just never happened. So I waited until I got a chance to talk to you here.
Sounds like fun.
Yeah, so your defendant in this case sounds like she was deceased, correct?
Yes, she was. Mm-hmm. She died about 2 years after the incident from unrelated causes. She was an elderly woman. She was born in the 1920s.
Oh, wow.
Yeah.
Well, then I have 2 questions for you. Number one, how did you handle that kind of inevitable sympathy a jury tends to have for an individual defendant, especially if they're super young, super old, dead, anything like that? How did you handle that?
Well, that's a really good question. I think she wasn't there, right? There wasn't really any representative of her there. There wasn't I had to open the estate. I had to open the decedent's estate to make a lawsuit against the estate. So there was no family member from up north where she lived. The only people there were the defense lawyers. And so it didn't really lend itself to sympathy. And I think I addressed it in voir dire with just a very open question. And I can't remember the exact question I asked, but, it didn't really become much of an issue. My opposition counsel really tried the whole case to demonize me. And it was always, Mr. Anthony, Mr. Anthony, Mr. Anthony. Like she'd say my name in this just like I had just done something really awful,
Come to the principal's office, Mr. Anthony.
Right. It was like that the whole discovery period. It was like that the whole trial. And, I never said, that's enough of that. Or I never went back at her and used her name. I just like rose above it. And I just said to myself, I'm not engaging on that stuff. I'm not here to defend my last name the way she's saying it. It's so childish. I just need to focus on my case. And I didn't let it bother me. And I say that because it was important to me. And I think it made a big difference in my case because I think she was doing that. She's smart. She did that with intent. She was trying to throw me off. She was trying to get me to be combative, argumentative, kind of nasty with her and put me in the shoes of that stereotype of a lawyer that really isn't trusted or really that nobody wants to be around. Like if I had taken the bait, I would have fallen right into that stereotype. So I think it was important for me to say and share with you guys that I didn't take that bait and I kept on my case. And it wasn't easy, but I did.
Yeah, that's a great point. And another way that defense sometimes does that with us is just objecting to everything and trying to get up in your questioning or throw you off. I remember, this was the first edge case I ever tried. I got 14 objections in my opening statement, and my opening statement was only 12 minutes long. And it was,
wow.
I mean, it was to throw me off. It was to make me uncomfortable. It was the second trial I ever had in my life. I was doing it all by myself. And it was like, I was like, oh God, am I doing something wrong? And I kept thinking, am I doing something wrong? And then I had such wonderful edge colleagues, and Dawn was available for me to speak to. And they were like, just focus on your case. You know what you're presenting, just keep doing it. And when defense does that, you just, if the judge asks for a response, do it, but don't fight back. Just kind of keep on it. And it worked. I mean, it really, really does work, because jurors do pay attention to that. And there are different schools of thought on whether you listen to what juries say to you after their verdict and whether you take it into account or anything like that. But they will talk about things like that. Well, I didn't like the way you acted, or the way you behaved, or the way defense counsel kept interrupting you, or however it may be. So just kind of human decency really comes into play. And that's something that we forget about because we're so focused on the evidence and the facts and that kind of stuff, right?
I love that, like, you're a younger generation compared to me. And when you said you did a 12-minute opening, I just love that. I love that the younger lawyers are learning to be more brief, and to focus their opening statements down to 12 minutes. I absolutely love that. And I know that they do object at times just to throw you off, and to be able to stay on your case through that is a challenge. So, thumbs up to you for in your second trial for actually accomplishing that. That's very cool, especially trying it alone. I mean, that's a big accomplishment.
It was a good case. Go ahead.
This is how I handled it in voir dire. Okay. I looked up my outline while you were talking, and I just simply said to them, I won't use her name here, but the defendant passed away 2 years after this incident from totally unrelated causes. And the law required that for my client to maintain her claim, she had to substitute the defendant for the defendant's estate. So we had to bring a claim against the estate instead of an individual. And then I put that out there and I let them talk about it. I opened it up to any conversation. And all I really got from this pool of potential jurors was they just shrugged their shoulders on. That's okay. We get it. It was kind of like no worries. We're all good. You can move on, sir, kind of approach.
Why'd you ask us?
Right. Yeah, you're fine. You're fine.
Yeah. Okay. All right. So would you suggest then, if we can, to keep defendants out of the courtroom? Because I've just been thinking about this lately. I know that in some corporate defense cases, you use that corporate defendant in your case in chief, and they can be super powerful for you, right? For us. But in an admitted liability car crash case, I don't know. I think in my experience, the defendant really only serves as a point of like, oof, I feel really bad if I levy a large verdict against that kid who's 17 and clearly doesn't have any money, because we can't talk about insurance. What do you think about that? Like, what are your thoughts on that?
Well, I don't think a judge would grant my motion to exclude the defendant from the courtroom. It's something I don't really have control over. I'll tell you a quick funny story. When I was a young public defender, I had a client who was gay and in the closet and was gay bashed by a minister's daughter because he was walking past her church. And she said some really awful things to him. This was back in the 90s. And she provoked him, and he picked up one of those concrete donuts that go around a sprinkler head. They're all over the place down here in Florida. And he kind of like juked it at her like he was going to hit her with it. And then he dropped it and he ran. And she called the police and they found him and they charged him with assault and battery because he had pushed her, And her father, the minister, was standing outside the courtroom, glad-handing and shaking hands with everybody, making a big production of himself, with his minister's, outfit on. And I went into the courtroom and I said, Judge, I want you to exclude that man from this courthouse. I want him waiting downstairs. I want him outside. He's trying to bias the jurors. He's trying to bias the witnesses. He's out there shaking hands with everybody. And she looked at me and she said, Mr. Anthony, I am not going to do what you're asking me to do. Your motion is denied.
Damn.
And so I get that, like, we want these things because we know that they, like, yeah, it's prejudicial. It has no basis on the juror's decision making. Like his presence there it's disruptive, But you're not going to get a court to agree to that. I can't imagine a judge agreeing with that. So I'd love the idea. Yeah. And if you succeed at it, Jenna, please tell me how you did it, because I want to try it.
Because guess what? You can't get it if you don't ask for it. So I might try.
All right.
And we'll see what happens. I don't know. I mean, as I'm thinking about it logically, I'm like, well, what do they do? Do they have the constitutional right to confront their accuser? I mean, I don't know. Do they?
Yeah, win, lose, or draw. I want a phone call after you try it. Okay. So will you do that?
I will let you know.
All right. Thank you.
But it's one of those things where I think about these things and I'm like, all right, you got to be careful what motions you bring. You got to be careful what you try to keep out. You don't want to be trying to hide things from the jury, because again, that goes back to the authenticity. So, we're going to try to keep the property damage photos out, but if they're in, you don't want to make a big deal. You kind of want to be careful about that stuff. So I'm going to try it and then we'll see. Because I do think, as I've been thinking about it and talking to Young G about it, I'm like, what are they even doing there? Because really all they're doing there is the defense gets to say, oh, my poor client over here is going to have to pay $7 million or whatever it is. And they don't got that kind of money. Right? I don't know. So I'll let you know. All right, let's see. Oh, so was your trial live or was it Zoom?
Oh, it was live. And we wore masks. The judge wore a mask. The clerk wore a mask. The bailiff wore a mask. The jurors wore masks. The lawyers, the clients, everybody wore masks, except when they got up on the witness stand, they were enclosed in plexiglass and they took their masks off.
Did you find there was any, sorry, go ahead.
No, go ahead. Go ahead with your question.
Did you find any issues with reading facial expressions or body language or anything like that with the face covered?
I mean, I want to say I didn't. I did not. I want to say it was okay. The strangest thing to me was after the trial, when we saw and talked with the jurors outside the courthouse and we all had our masks off, they all looked so much different than I imagined how they would look. But I could see their eyes, I could see, their foreheads, their facial expressions, the lifting, tilting to the head, the shoulders, the leaning in the chair. Like you could still see their body language. You could still see a large portion of their face. I felt like I was challenged to make very difficult decisions in voir dire about who we were going to deselect or select for the jury. And as it turned out, our decisions were excellent.
Good.
Even where we had to weigh them, it was a very difficult process, because there were real negatives to a lot of the people that we did end up allowing on the jury. So I think that what we were able to sense, even with the masks on, was enough to make good decisions.
Okay. All right. That's good to know. Have you done any Zoom focus groups? It sounds like you have since figured out a way to do them. And how have you enjoyed them?
I like live focus groups a lot better. I enjoy them more. But if I can't do a live focus group, I'm going to take a Zoom focus group, right? I'd rather do it live, but if I have to, I'll do it by Zoom. The
Absolutely.
important thing is that I do focus groups.
And are you having any Zoom trials down there, or is everything live?
What they're doing is allowing witnesses to appear by Zoom.
Okay.
Some judges are allowing that. I haven't had that experience yet.
Okay.
I have a case probably going in the last week of January, so we'll see.
Yeah, we'll see. Interesting. We're kind of the opposite up here. It's county to county. It depends, but predominantly Zoom trials right now, which since we've been doing Zoom focus groups, it's good practice for that because it's a different animal for sure.
You're actually doing Zoom trials.
Yep.
Are the jurors in the courtroom?
No.
The jurors are what? Wherever they live or whatever?
Or work or in their car. I mean, there have been some. Okay, so I think there are pros and cons to this whole thing, right? I think the pros are we get a bigger response from people who don't have to take public transportation to the courthouse, who don't feel safe coming to the courthouse, because at least up here, the courthouses are very, very dangerous around, the area around them, or for other reasons might not show up or answer the call. But then the other side of it is, they're in their house, they're in their office, they're wherever they are. And, I heard a horror story of one person whose juror got excused because she kept sleeping. It's definitely different, but doing a focus group in whatever, I guess, manner you're going to be trying your case is important because, if you do a Zoom focus group in a because you're going to do a Zoom trial and you have somebody who's not paying attention or who's falling asleep, then you know how to, deal with it. You're ready for it. You're like, okay, I'm going to ask the judge about this. Or I'm going to be like, oh, juror number 14, are you okay over there? Or whatever, however you're going to do it. But you have practice and you've dealt with it, right? And it's not a surprise to you.
Yeah. I mean, one of the things that was really important to me in this case, I had never done a trial with masks. I hadn't done a COVID trial and I had to embrace it. Like at some point before we started, maybe even like the night before or the morning before we started the trial, I had to tell myself, you have to embrace what's happening here. You will not know every outcome. This is new. You have to be okay with this being new. You have to be okay with not knowing how everything's going to go in this masked environment. Be okay with it, embrace it, and you're going to do fine. So there was a certain amount of letting go of managing expectations. Like I can't manage what I have never done before, what I've never seen before, and I haven't even talked to anybody who's done it. So I'm going to be all right.
Yeah, that's an excellent point. Got to kind of just be okay and then forgive yourself and be kind to yourself because it's like, and everybody else, I do feel like in some of the more challenging situations, everybody kind of comes together and, maybe even defense counsel is a little bit more friendly and whatever, because you're like, we're all dealing with this really strange situation. So, I can't yell at you for something that I'm probably going to do in the next 5 minutes, something like that. Okay. So you talked about your number, you have kind of a magic number, 1.4, that seems to be working for you, but how do you address that with the jury? And do you address it with them during voir dire? And I ask you because there are several ways I have heard people doing it. You'll ask, hey, I'm going to be asking for many millions. Is there anybody who has a problem with compensating with many millions, kind of as an anchor? Dawn has given the example of saying, some lawyers will ask for the moon, hoping to fall somewhere in the stars. Do you want me to ask for the moon, or do you want me to ask you for the number I think it's worth? How do you do that? And what do you feel works best, and what worked in this case?
Well, I didn't touch money in voir dire. I didn't touch money in opening statement. I didn't ask for a number until the closing argument. And that is something that I do in every case, unless I choose not to ask for a number at all in the trial. And every once in a while, if I have I had a trip in a sidewalk, an uneven sidewalk, and the liability was so close, I didn't need a lot of money to win. And so I didn't ask for a number, so I needed my credibility more than anything else. I've been taught that because we, as the plaintiff lawyers, have this negative image, okay? If you in voir dire do all the right things, if you're building your tribe, if you're building trust, if you are explaining your client, and then you start to talk about money, I've been taught that at that point, a reaction that you might have from the jurors is, oh, okay, there he is. That's the guy I was expecting, right? So the idea is I haven't earned my trust yet to go into asking for money. Same thing in opening. I haven't earned the right yet to ask for money. Now, in 2014, I hit a verdict for $11 million, not putting money in the voir dire and not putting money in the opening, not even discussing it, like you said about the moon and the stars, or a really big number, or, I'm going to ask for a really big number, who has resistance or difficulties with large awards. I'm not going to say what large is. That's up to you to say. I don't do any of that. There are lawyers, like great lawyers, like top lawyers in the nation who do, but I personally don't. And I've done really well not asking for a number until closing. It feels better to me. And that's what I go with. So there are definitely different ways to do it, but that's how I personally handle it.
Okay. And is the number you asked for at, I guess, in closing, the number you got? And was it also the number you felt it was worth, or did you do a double or triple or inflation and hope they, gave you something between what the defense was asking for and what you asked for?
No, they gave me exactly what I asked for, like to the dollar.
Wow.
And it was the same with the other $1.4 million verdict, and I didn't ask for a higher number hoping to get half of it. And I didn't condition the jury in voir dire and say to them, do you want me to ask for what I really think the case is worth? Or do you want me to double it, believing that you're going to cut whatever I asked for in half? I don't do that either. Even though many of us are taught to do that, I choose to leave that part out. Because I have faith that I'm going to gain the credibility, that they will understand that I'm asking for what it's worth, even without having that conversation. Like, I put my faith in my ability to establish that credibility.
That makes sense. That's good. Okay. Well, we are at the end of our hour. I know it goes so fast, but thank you so much, Neil, for being here. And thank you for all of you who joined us for this week's episode of Fridays with Keenan's Cutting Edge. If you liked today's episode, please click that thumbs up and don't forget to subscribe and sign up for alerts so you don't miss an episode. Next week, we will be hearing from Greg Luther again, a guest so nice we had to have him twice. And spoiler alert, I actually want him to come back again and talk about black letter law. So he will speak 3 times, but I'll kick him out of ways so we don't have too much Greg Luther. Can you have too much Greg Luther? I don't know. Well, one of his many specialties is black letter law, and that's why I want him to come back and speak about that. So be on the lookout for that episode next year. Next week, Greg is going to speak to us on obstetrical malpractice. As many of you know, Papa Don has a great passion for cases involving children, especially medical malpractice with child victims. He has an entire wall in his Atlanta office dedicated to the sweet little ones that he has advocated for throughout his career. He heads up the Keenan's Kids Foundation and has even changed laws to protect our society's most vulnerable. So he personally chose Greg to speak on this topic, and is going to be good. I'm excited to learn about what Greg has to say with all of you. Have a wonderful weekend, and I'll see you guys next time.